that's never going to change. Then in a document, you could say, I want you to stop what you're doing. I don't need my daughter to tell you what to do. I don't need my wife to tell you what to do. I'm telling you what to do. That's the living will, okay? And by the way, you could say, if I can't blink my eyes, if once for yes, twice for no, if I'm at the end of my life, no, don't stop, keep me going. If that's what you want, then you put it in the living will. They'll keep you going until you actually have died, yes.
Is this different than a medical directive?
No, these are medical directives.
Okay, so when you...
These are different types of medical...
everybody should have their own medical... I have one all over the place.
Right. Yes, everybody should have one.
Okay.
Including Alex, yes.
Yeah. Okay, because in New Jersey...
Yeah.
Is that still in existence, that if two doctors write that you want to end your suffering if you're within 6 months of dying,
right.
You have the right to do that?
If you put it in the document.
But I thought that was a law in New Jersey.
If you put it in the document. You have to have a document that says that. It's not going to just happen automatically, okay? So what we're saying here is, for instance, New Jersey's law says, again, if you can't communicate in any way, if you're not going to get better, if you're nearing the end of your life, in a document called a living will, called a medical directive, okay? Living will is a type of medical directive. You can say, if I have 6 months or less in this terrible condition, I want you to stop what you're doing, okay? Now, what if you don't have a living will? I mean, that's really your question. What if you don't have any documents at all? Thanks to President Obama, okay, we have the Affordable Care Act, and within the Affordable Care Act, we now have a document called a POLST form, P-O-L-S-T. And it's in New Jersey, it's on green paper, because it's so important. We want people to know it's different than all the papers that are on white, all the documents that are on white paper. I don't call it a POLST form, I call it the green form, because I'm intellectually, stunted. All right, so the green form, the POLST form, is actually completed by the doctor. It's not completed by you. And nursing homes and assisted living facilities are the reason why I'm now bald. Elizabeth knew me when I had hair, okay? Because I'm constantly pulling it out, because the nursing homes and the Sunrise, the assisted living facility, they'll give the green form to the family and say, fill this out and bring it back. No. Number one, it's only filled out when the doctor makes a determination that the patient is nearing the end of their life. I've got clients that are coming into my office that are 30 years old and doing their will, and they want, when Sister Felicia used to put a star on my chest, they want me to put a star on their chest because, look, I did the POLST form. Oh, what did you do a POLST form for? You're not dying anytime soon. You're perfectly healthy. So this POLST form, the green form, is filled out by a doctor, and the doctor is talking to the patient, and if the patient's too ill, as they probably will be, because it's not a fun conversation, so the doctor will wait until the patient's too ill, so the doctor doesn't have to talk to the patient. Instead, the doctor will talk to the family member who's on the medical power of attorney and say, do you want your mother to be resuscitated if she has a heart attack? I don't know. Let's talk about it. Okay, that's what I'm here to do. That's what the doctor is there to do. And you'll have a conversation. And the doctor, maybe the daughter says, I don't know what mom wants. Does your mom have a living will? Yeah, well, let's read it, because it'll tell us what she wants. And then the doctor will order either do not resuscitate or whatever. Well, let's go to the next question. If your mother needs dialysis, do you want her to be on a dialysis machine? If she needs nutrition, do you want her to be on a feeding tube? This could be an hour's conversation. Doctor's filling it out as he's taking information from the child or the patient on the medical power of attorney, looking at the living will, and then the doctor signs it, the patient or the patient's medical power of attorney signs it, and now that is the doctor's orders. And anywhere that patient goes, that green form follows. You can always change it, but assuming you don't, that green form now tells us what to do or what not to do. So it's a continuum. You start with the medical power of attorney for different things while you're sick, but you're not nearing the end of your life, but maybe you can't communicate. Then you're getting near the end of your life, and we're going to do a POLST form and look at your living will so we can figure out what you wanted to do. But if you don't have a living will, okay? Then the doctor has to talk to all of your next of kin, and that's not easy, okay? What if you have a next of kin that you're estranged from, right? Your son who's been living in California with Hare Krishna for 30 years and you haven't talked to him, okay? We're going to have to find him because you didn't do a living will. We don't know what you want, and we can't just rely upon your daughter who happens to be here. So that's why you want to have these medical documents. So durable power of attorney, medical power of attorney. In New Jersey, it's called a proxy directive. Living will, in New Jersey, it's called an instruction directive. If they're all in one document, it's a combined medical directive. It's all the same thing. Yes, ma'am.
Is a living will the same as a trust?
No. No, living will is a medical document. You're thinking of a living trust. That's something different. These are medical documents. And then the last document is your last will and testament. When you die, those first three documents end, and then we look at your will. Your will is going to tell us who's in charge. That's the executor of the estate. The executor pays all your final bills, and then the will tells us who gets what. So you really do want to have a will. What happens if you die without a will? Number one, the state of New Jersey tells us who gets the money. It's not going to go to the state of New Jersey, but there's a statute that tells us who's your next of kin, and that's who's going to get your because you haven't told us. You didn't take the time to tell us. Well, now we'll have to abide by New Jersey. There could be a fight over who's going to be in charge because you didn't name an executor. All right. So if you got 3 kids, they all have an equal right to be in charge. God bless them. Let them fight it out. Some judge might have to decide who's going to be the administrator. Why? Because you didn't take the time out to do a will. And even if you have children that get along, and the 2 children say, "All right, we'll have Bobby be the administrator," Bobby has to post a bond. What's the bond? The bond is an insurance policy to make sure Bobby doesn't steal the money. And it has to be done in every single case unless you have a will. Because every will says my executor does not have to post a bond. Any will I've ever done says it. So there are good reasons why you should have a will. Now, within a will, you might have a trust for different reasons. Okay, so we're up to an hour. I've got one more. I'm going to answer Victoria's questions because there's always one in the crowd that has a lot of questions. That's Victoria. All right. But so far, they've been good, Victoria. I hope this one's good. But then there's one more little thing I want to tell you about that living trust that you had asked me about. Yes.
So I have a client who, I work in the, I'm a daily money manager for money. Alexandra, they and I refer clients to them when they can't afford me. But so I pay people's bills and administer various things and talk to lawyers about getting trusts and wills and all their paperwork in order. But my question is, I have a client who had a son who had a special needs trust.
Right.
And he passed away.
Right.
She set up these trusts, and she's paying quite a bit of money to the accountants every year to do the accounting on these trusts.
Right.
And she really doesn't need them anymore because she only has one son left.
Mhm.
So she doesn't need the trust. She has a will that says I'm leaving everything to my son.
Okay.
So
The trust should have a clause that says when the special needs child dies, what happens? So the trust could say when he dies, the money goes to the other son.
if the trust, you can set up trusts that aren't funded. This trust isn't supposed to be funded until she dies.
Okay. Well, then the trust is and in the meantime, the son it was set up for died.
Right.
Okay.
But there was a second trust set up for the son who was still living, so that the money would be split equally.
Why was the accountant doing accountings if there was no money in the trust? Doesn't make sense.
I don't know, but
Yeah.
I asked him, how do we dissolve the trust? And he said, are you a lawyer now?
Right. So the answer is you can defund the trust. There is a way to defund the trust. It depends on. I got to read the trust. I can't. There's so many different ways, right? But I'm saying if you have a trust and it's set up for Johnny, and there's money in it, and Johnny dies, the trust is going to tell you who gets what's left in every case. Okay. So I'd have to read it. But I want to answer your question. So there's this thing out there called a living trust, or a revocable trust. What is it? What do we need it? Or why do we need it? Or do we need it? So in New Jersey, when you die and if you have a will, you have to probate the will. Probate is the process by which you bring the will to if it's in Bergen County, to the Bergen County Surrogate's office. And a nice lady there, they're all ladies, last time I looked, will look at the will to make sure that the lawyer did it properly. Okay? And then they'll say, all right, give me a check for $200 or $250. It's usually never more than that. Even if you're a multimillionaire, it doesn't make any difference. You're charged by the page of the will, not by how much money you have. And then they give you a piece of paper that says you're in charge, you're the executor. Bing, bang, boom, you're done. So probate in New Jersey literally takes 10 minutes. Okay. Probate in Florida could take 3 years and cost $10,000. Probate in New York, I've got a probate in New York now that's going on. I think we're in our 5th year. Okay. Probate in California, same thing. Very expensive, very time consuming. So people want to avoid probate in those states. The way they avoid it is they create a living trust. Why is it a living trust? Because you're creating it while you're alive. It's revocable because you can change it whenever you want. You're the trustee and you're the beneficiary. So it's your alter ego. It's no different than you. It doesn't help you with Medicaid. But when you die, the trust tells us where the money goes instead of the will, and you don't have to probate a trust. So you beat probate in those states, okay? So, but when we do trusts, unfortunately, lawyers charge more money to do trusts than they do wills, especially in New Jersey, because we don't need to do a living trust. And the other headache with a living trust is everything you own, including your car, has to be in the name of the living trust. Because when you die, we need to then get it out to the people you want it to go to. So there's nothing in your name anymore. Okay, even your bank account, it's in the name of the Bob Romano Living Trust, Bob Romano Trustee. So it's still my signature. Okay, so when you hear, and she's the bane of my existence, Susie Orman, I think that's how you pronounce her name on the radio, all she talks about apparently are these living trusts. Okay, Susie apparently doesn't live in New Jersey. Okay, it's these other states. Now, if you happen to be wealthy enough that you live in New Jersey and you own property in Florida or in California or in New York, you may want to do a living trust just for that piece of property. So you don't have to go to probate in that state, but you don't need to do it in New Jersey. All right. The last thing that I want to leave you with, Alex was all set to go over there and say goodbye, and I got it, is this. There are companies that are selling these living trusts, not so much now, but they were for a long time in New Jersey when we really didn't need them. And why? They saturated the market in Florida because everybody in Florida, I think when you're born in Florida, mom creates a living trust for you because everybody's worried about probate in those other states. So they started coming into New Jersey, and they had helpful lawyers here in New Jersey that would give seminars like this one, and they would literally sign you up in the corner of the room, okay? And when they did your documents, they would give you a fancy binder. And you usually got charged about $1,000 more than what the New Jersey lawyer would do if you just went to his office. You were paying for the binder, I guess is what I'm saying. You know, when I do your will, you're not getting a binder from me. You're just getting a piece of paper that says, here's your will, okay? You get your own binder. So, if you're going to a seminar and they're trying to sign you up on the spot, or as soon as you see that binder, run for the hills, okay? My mother, God bless her, every year for the last 10 years of her life, when she was at the Record, is the newspaper here in Bergen County, she would see in the Record the little advertisement, come and get a free dinner and, talk about estate planning. And I'd say, Mom, go for the dinner, but please don't buy anything, okay? And by the way, that's also true with Medicare. I just thought of this, okay? Medicare, traditional Medicare, old-fashioned Medicare. Stay with the old-fashioned Medicare. I don't care what Bob Goulet says or it's Tom Selleck or whoever is on at 2 o'clock in the morning on, and they're trying to sell you on Medicare Advantage or whatever. You don't want it. if you have one of these HMO Medicares and you get sick and you're in the hospital and now you have to go to rehab, you can't pick your rehab. The HMO picks your rehab. That doesn't happen with traditional Medicare. You have traditional Medicare, you can go to any nursing home you want. You can get your rehab wherever you want, okay? So, I understand that you may get a couple of dollars off on the monthly premium for the HMO, and you get to go to the health club that you're really not going to go to. Don't go with the HMO. And if you're in the HMO now, whenever it's that time of the year when you can get back into traditional Medicare, please do it. I really think it's a good idea. All right. Before Victoria can ask another question, all right, I'm going to say, thank you. And ladies, thank you very much for your patience. I'll stick around for a few minutes if you do have any questions. It's the only time you're going to get a lawyer to answer a question for free. So, take advantage of it. All right. Thanks a lot, folks.
I have a question. Did you say that Medicaid would pay for assisted living?
Yes. But the assisted living will make you pay for 2 years before it takes to
Oh.
Two to three.
But
Suppose you don't.
in some places 3. Yeah.
Okay, thank you everybody for coming. And like he said, he'll be here so you can ask him some questions, okay? Thank you everybody, and I'll send everybody the next